Appeal in the matter of Ackom and the Secretary of State for the Home Department.
Mr. Malik.
My lords, my lady, I appear for the Secretary of State this morning, who is the appellant in these proceedings. My learned friend, Mr. Stedman, appears for the respondent, Mr. Ackom, also known as Mr. Bounsu, along with Mr. Pollinger.
Yes.
My lady, my lords, Mr. Bounsu, as you will have noticed from the papers, is a citizen of Germany, and the Secretary of State seeks to deport him to that country in the light of his criminal conduct. You will have seen from the papers that he has received a total sentence of 4 years and 1 month in custody following his convictions for possession of cocaine and cannabis with intent to supply and possession of a bladed article in a public place. The First-tier Tribunal has held that his deportation would be incompatible with Article 8 of the ECHR, and the Upper Tribunal has upheld the First-tier Tribunal's decision. I shall seek to persuade you, my lady and my lords, that the First-tier Tribunal's decision is wrong in law, and therefore it was not open to the Upper Tribunal to uphold it. My lady, my lords, there are 2 grounds of appeal. The first ground concerns Section 117C, 4 small c of the 2002 Act. That provision stipulates the test of very significant obstacles to integration in the home country. The second ground concerns Section 117C6 of the 2002 Act. That provision stipulates the test of very compelling circumstances. Now, my learned friend and I have discussed the issues in the appeal. And my lady, my lords, it is common ground between us that there is no need for the court to consider ground 2. The central issue in this appeal concerns ground 1. If ground 1 fails, the appeal fails and will be dismissed. If ground 1 succeeds, my learned friend and I agree that the court will have 2 options. Option A would be to remit the appeal for a fresh hearing at the First-tier Tribunal. And option B would be for this court to proceed and remake the decision as to whether the exception in Section 117C4 applies to this case. If ground 1 succeeds, I will be inviting the court to remit the appeal for a fresh hearing at the First-tier Tribunal. I understand that my learned friend will invite the court to remake the decision, essentially as a first instance tribunal. My learned friend is not relying on Section 117C6 of the 2002 Act. He's not suggesting very fairly and properly that there are very compelling circumstances over and above the 2 exceptions. The outcome of this appeal, therefore, depends on the court's conclusion as to ground 1 and Section 117C4.
I'm just trying to work out how that pans out, Mr. Malik. Understand why 117C6 doesn't come into the picture. But your ground of appeal is that the decision is perverse, it's irrational. If it's irrational and no reasonable judge, specialist judge, could have applying the 117C4C test to the facts of this case, could have reached the decision that this judge reached, then isn't there only one conclusion that could be reached? In which case, what are you remitting it for?
Absolutely, my lady. My ground, as you will have seen from my skeleton, has 3 limbs. The first limb is that there was an error in approach. The second limb is perversity, and the third limb is inadequate reasons. So if I'm able to persuade the court as to limb 1 or limb 3 approach and adequacy of reasons, remittal perhaps would be the right outcome. But if the court concludes that the decision is irrational, perverse, then Milady is absolutely right that the only outcome would be to substitute a decision dismissing the appeal. So subject to any observations, what I therefore propose to do is really focus on ground 1. And I propose to address you first on the statutory framework and the law. And I will then make some brief submissions as to the facts and the decisions made below. Now, dealing first with the law, Part 5A of the 2002 Act is behind tab 1 of the authorities bundle. And Milady and Lords will see that section 117A provides that the provision applies where a tribunal or court is considering the question as to Article 8, and subsection 2 requires the court or tribunal to consider, this is subsection 2B, the considerations listed in section 117C when considering the public interest question. Section 11C is at page 3 of the bundle. You will see that there are 7 subsections. Subsection 1, subsection 2 provide general principles. Subsection 3 says that a criminal who has not been sentenced to a period of imprisonment of 4 years or more, the public interest requires that criminal's deportation unless exception 1 or exception 2 applies. Now, this appellant, Mr. Bonsu, as the court knows, has received a total custodial sentence of 4 years and 1 month, but he falls within subsection 3 because of the effect of section 117D. But the relevant exception is exception 1, which is at subsection 4. You'll see that it has 3 limbs. There is no issue as to limb 1 and limb 2. And you'll see that limb C says that there would be, the exception would apply where there would be very significant obstacles to C's integration into the country to which C is proposed to be deported. So this appeal is really about that provision. There are five short points that I make about that provision. Milady, my lords, my first point concerns the meaning of the phrase very significant obstacles. Now, this court dealt with that phrase in Paween. You have that authority behind tab 8 of the authorities bundle. And the relevant paragraph is paragraph 9, which you have at page 150 of the bundle. You'll see that at paragraph 9, Lord Justice Underhill referred to the decision of the presidential panel in Trebawan, and then endorsed the approach subject to a slight modification. The basic point made is that the word very has a role to play. And what that word reflects is an elevated threshold. The threshold which will not be met by mere inconvenience and upheaval. The task of the tribunal is twofold. First, to identify obstacles to integration, and then decide whether they are very significant. The second point that I make, milady, my lords, is about the meaning of the word integration in section 117C, subsection 4. Now, this court considered that word in Camara. You have that authority behind tab 6 of the authorities bundle. And the relevant paragraph is paragraph 14, which you have at page 134. That deals directly with section 1174 small c. And you will see that Lord Justice Sales, as he then was, said that the idea of integration calls for a broad evaluative judgment. And the judgment entails whether the individual will be enough of an insider in terms of understanding how life in the society in that other country is carried on, and a capacity to participate in it, so as to have a reasonable opportunity to be accepted there, to be able to operate on a day-to-day basis in that society, and to build up within a reasonable time a variety of human relationships to give substance to the individual's private life. So the words to focus in my respect, the phrases to focus in my respectful submission are enough of an insider, capacity to participate, and reasonable opportunity to be accepted there.
There's some striking similarities between the facts in Camara and this case, aren't there?
Yes.
Apart from the fact that there was very nasty illness virus going on in Sierra Leone at the time, but very significant obstacles were found there and upheld by this court in circumstances where no family there, no cultural ties, no social ties, held not to be irrational.
Yes, but of course the key difference here is that, and you'll hear submissions on this, that Mr. Bonso is being deported to Germany.
Yes.
And that has a role to play.
Germany is a different type of country, I get that.
Yes. Yes, but lady, given that you've asked that question, if you look at the next paragraph, paragraph 15, you'll see that there was no issue in that case as to the way in which the tribunal had directed itself in law. And this is paragraph 16. Again, there's no issue as to the direction, as to the law, and the issue before the court in that case was whether the decision fell within the range of sort of reasonable responses. But this case, for the reasons that I will explain very briefly in a minute, is different. Now, the third point that I make is about the meaning of the words enough of an insider, the phrase that Lord Justice Sales used in Kumara. Now that the use of that phrase in fact generated some controversy, which was settled by this court in AS Iran. Now AS Iran is behind tab 3 of the authorities bundle. And a submission was made by the appellant in AS that whether someone is enough of an insider is to be determined by reference to their ties or links to the other country. That submission was rejected by this court at paragraph 59. And what the court said was that this is not what Lord Justice Sales was seeking to say in Kumara, and it is entirely legitimate to have regard to generic factors in considering that phrase. The generic factors would include how the society works in the other country, cultural considerations, language barriers, and so on and so forth. So the focus must not be solely on the links or ties of a person with the country of return. The fourth point that I make, my lady, my lords, is about the relevance of a person's criminal conduct and character to the assessment of section 117C4. The authority that assists in relation to that question is the judgment of the Supreme Court in Sanbar. You have that behind tab 9 of the authorities bundle. In a deportation case, the offence was the offence of robbery, and the paragraph that I respectfully if you go to page 171 of the bundle, you'll see that the Supreme Court referred to what Lord Justice Sales had said in Kumara, effectively endorsed that approach as correct. But then if you look at paragraph 61, which is page 172, you'll see that you'll see the way in which the Supreme Court said that a person's character and offending can be relevant. The offences in that case demonstrated that the appellant was very assertive, and that showed certain robustness of character, and that was of some relevance. So if for example, a person has dealt with other individuals in committing a crime, then that may shed light on that person's ability to deal with other individuals, to communicate with them, and to find a way.
I know you're coming to the facts later. Here, there is a suggestion that Mr. Bonsu committed these offences because he'd incurred a gambling debt,
Yes.
and then he and his mother had been threatened,
Yeah.
and he had given in to those threats.
Yes.
In those circumstances, it doesn't sound so much like robustness of character.
Lord, I will of course address you on that point, and I'll address you by reference to facts and to the materials. Well, this particular paragraph 61, was considered by the Supreme Court again in a case called SC Jamaica. You have that authority behind tab 10 of the authorities bundle. Again, a deportation case And if you go to page 202 of the bundle, you'll see a heading, the third issue, and you see that that issue concerned section 117C4. The paragraph that deals with this limb is paragraph 107. You will see that the Secretary of State made a similar submission in that case, which was rejected. The submission was that the decision maker had failed to pay adequate regard to a person's criminality as potentially showing a certain robustness of character. The submission was rejected because in that case there was medical evidence that SC had highly complex needs. He was suffering from PTSD, there's a long history of depression, a trauma in the childhood, and therefore the Supreme Court said that that plainly wasn't the case where the criminality showed a robustness of character. But the point that I am seeking to make at this stage is a general point, which is that robustness of a person's character can be relevant. The fifth and final point that I make concerns proper approach in considering social and cultural connections in the context of an assessment under section 117C4. Well, those words, social and cultural considerations, were addressed by this court in Binbuga. You have that authority behind tab 4 of the authorities bundle. A deportation case, it's about the exception that this court is dealing with. If you go to page 90 of the bundle, and if you look at paragraph 56 first, you'll see that 2 points are made. The first point is that membership of a pro-criminal gang tells against rather than for social integration. There was a point where when the tribunal took the view that the fact that a person is member of a gang demonstrates that he has integrated well into society.
One can see why that submission didn't stand.
Yes. But there is the second point that is made in that particular paragraph, is that social integration, the concept of social integration, refers to various incidents of society such as clubs, societies, workplaces, or places of study. So when one is considering or assessing social integration, these are the sort of matters that the decision maker is obliged to consider. Paragraph 57 deals with cultural integration. And you will see that that phrase refers to the broad culture, the core values, ideas, customs, and social behavior. When considering and assessing whether cultural integration is possible, the focus ought to be on those sort of matters: core values of a society, ideas, customs, and social behavior. So these are the 5 points that I wanted to make on law. May I now, unless there are any observations, move to the facts and the decisions made below.
Can I just ask, if just 3 limbs of exception 1 are satisfied, does that always outweigh the public interest in deportation under subsection 1?
Yes, as long as the person has received a sentence of less than 4 years. absolutely. This is what this court has said. This has been approved by the
That's
Supreme
what I
Court.
thought the position was.
Yes. Now, may I just take, Lady Lords, take you through the relevant documents that are really material in a chronological order. And the first document that I want to show you are the sentencing remarks of the judge.
Before you do that, can I ask you one other question?
Yes, of course.
Which is, we saw from Kumar Lord Justice Sale saying that case didn't raise any issue of principle. Is there an issue of principle in this case?
There is, yes.
What is the issue of principle?
This is really paragraph 15 of my skeleton argument. Now, this is the first case that, of course, I know of, and that has come before the court involving an EEA national following the UK's exit from the European Union. So the issue of principle is how the fact finders should approach deportation of foreign criminals to another European country. Now, prior to the UK's exit from the European Union, there was a different regime for.
He couldn't have been deported, and he couldn't have been deported if he'd applied under the EUSS, but he didn't.
If he had, there could have been an argument on that, but
He wouldn't have got anywhere, Mr. Malik. You know that because of the level of severity of his criminal offending. It's too low.
well, yes, but of course the UK is now not part of the European Union. The position that Milady is absolutely right. The prior to the UK's exit was that there was a different regime that applied to criminals from European Union. And I think, in fairness, I have to accept what Milady has said.
I mean, one of the ironies of this case is that if he'd got his socks on and actually applied under the EUSS, we wouldn't be having this debate.
Milady,
But does this, in answer to my lord's question, I mean, does this case actually raise a principle relating to EU nationals in particular? Because isn't the position now that they're treated like everybody else? I mean, any type of foreign criminal is subject to the same Article 8 regime as before.
yes,
Yeah,
but the point of principle in my respective submission is that how one should approach cases where a person is being deported to a country with common cultural considerations.
Right, so another part of Europe, in other words.
Another part of
Yeah.
Europe, yes. So if this case, I mean, I entirely accept that if the offending was prior to the UK's exit from the European Union, then a different regime would have applied, and Milady is absolutely right that it would have been difficult, put it this way, for the Secretary of State to deport him. But here, of course, the offence was committed in 2022. So even if he had applied under EUSS after the exit of the UK from the European Union,
Be the second bit of
Yes.
the withdrawal agreement that applied.
yes.
Another
So
type of
it's
new
not that
regime.
there's some special status in law of a new state. It's that on the facts, you say that European countries share a common culture to a certain extent with the UK, and it's a relevant factual
Yes.
point.
Yes. So the point of principle is whether that is a relevant factor
I see.
in the assessment, and if so, how should one approach it? How should one compare the UK's culture with the culture of another EU state, and how should one go about the exercise of considering whether there are very significant obstacles to integration into that country. Now, the first document on facts that I'll take you to is the sentencing remarks. If you have the supplementary bundle, the sentencing remarks are at start at page 37. My Lord was absolutely right when my Lord observed earlier that the appellant wanted to pay a gambling debt. This is page 38, paragraph in the middle. The mother reported the matter to police, and that was the basis of the prosecution. But what is relevant in my submission for the present purpose is what appears at the end of page 38 and at page 39. Now, this is where the judge dealt with the circumstances of the offending. You will see that this is the end of page 38. The appellant, Mr. Bonsu, was a street dealer. You'll see that he was selling cocaine. There were 200 wraps plus some powder concealed in the underwear with marketing messages, large amount of cash, and in a car. The judge says that the appellant has expressed no remorse whatsoever. Now, if you then look at paragraph 39, second paragraph, this is, despite the causes of the offense, this is the role that he played. The offense fell within the significant role category, so his role was significant. The first offense, this is the next paragraph, falls at the bottom of the range of the significant role. But the fact, of course, is that the appellant, Mr. Bonsu, was a street dealer. So he knew how to deal with, how to sell drugs. The next paragraph, you'll see that the second offense was wholly different. The second offense involved a far greater amount of cash and drugs. And the sentencing judge said that Mr. Bonsu was clearly a very, very trusted lieutenant to be out selling with that quantity. So Mr. Bonsu knew how to deal with the suppliers, to get the drugs, to conceal them, to sell them on the street. So these are the facts that, in my respectful submission, shed light as to Mr. Bonsu's ability to engage with different people, to sell a product, though unlawful, and to go about his life in circumstances that are challenging. The next document is the Secretary of State's decision. This is the deportation decision, which you have in the core bundle at page 91. Of course, it's a comprehensive decision, so I'll take you straight to the relevant part of it, the part that deals with the exception. If you go to page 96 of the bundle, look at paragraph 27. Secretary of State referred to the sentencing remarks, fact that there was no remorse, none whatsoever. It's paragraph 27. Paragraph 28, the Secretary of State makes the point that he is being deported to Germany and would face no language barriers on return.
Well, that was because he was believed to speak German, and that turned out to be wrong.
Yes, lady's absolutely right. But that is paragraph 28. But an alternative point is made at paragraph 29, which is that in any event, there is prevalence of English in Germany. Now, there is reference to objective evidence. I will not take you to that evidence. It's in the supplementary bundle if you wish to see it. But you'll see that what it says, that there is prevalence of English, around 60% English proficiency in Germany. Around 60%. Far much higher than France, Italy, and Spain. Germans, this is the end of paragraph 96, are much more rigorously schooled in English. And most of them now learning as soon as they start primary school. If you look at the next page, page 97, again, the objective evidence which you have in the bundle, English is widely spoken. Expats and longer terms stays, the local administration also speak English, which makes setting up residency paperwork much easier. So that was the first point, essentially the second point that was made by the Secretary of State. About language in Germany. Then if you look at paragraph 31, there is a point about culture and customs of Germany. There's nothing to suggest that you are estranged from the culture of Germany. I'll make a point about this when I'll show you the decision. Or that you could not settle there. Paragraph 32, the Secretary of State noted that the appellant studied and worked in the UK, obtained qualifications that could be used in Germany on return, is in good physical health, and would be able to avail employment opportunities. But then the Secretary of State considered an alternative point, which is, well, we'll assume that he's unable to find employment. The Secretary of State then considers the objective evidence from the European Commission Department of Employment, Social Affairs and Inclusion. You have that document in the supplementary bundle. I will not take you to it. There's no dispute that this paragraph correctly summarizes that document. There is a reference to a 55-page booklet. You have that booklet in the supplementary bundle. There's a range of benefits. Of course, this is, given that lady sought to draw a comparison between facts of Kamara and the facts of this case. This is, of course, not Sierra Leone or Germany. A first world country where family expenses relating to young children, young persons, maternity, paternity benefits. There's a comprehensive range of benefits. And it would be open to Mr. Bonsu, the Secretary of State, said, to avail of any relevant entitlements on return to Germany. 34, the appellant was considered to be capable of adapting to a foreign language and culture, and it wasn't accepted that he would not be able to adjust on return. No evidence that he has been estranged from the culture of Germany, and in all the circumstances, the deportation was considered to be in the public interest, and the exception did not apply. Before I take you to the first-tier tribunal's decision, may I just show you the evidence that the appellant had used in the form of his witness statement. And this is,
Say a lot. He says he trained as a bricklayer.
yeah, so this is page 3 and page 4 of the supplementary bundle. And that is it. This was the evidence from the appellant. Now, if you look at that witness statement, it's a very short statement, some 9 paragraphs. Paragraph 3 says that he came to this country when he was 7 years old. Paragraph 4 is about schooling in this country. So he completed his GCSEs and A levels. Then page 4, he worked in the UK, including at Debenhams and Tesco's. So 5th paragraph is about work in the UK. And then the 6th paragraph is about his social life. Cultural and social considerations are relevant. So all he says really is that he plays football. So that really is the extent of his social life. Then paragraph 7, he learned, he was engaged in bricklaying and construction education in prison, and had an ambition to play professional football. Paragraph 8, he has no relations in Germany, cannot speak German language. So this was the Mr. Bonsu's evidence, and one of the questions that the court will consider is whether on this evidence the finding that there were very significant obstacles was justified. The witness statement does not, it's quite clear, deal with the issue of very significant obstacles. Nothing in it as to why the appellant does not have capacity to participate in the life in Germany, capacity to participate, the words that Lord Justice Sales used. Nothing as to why he would not have a reasonable opportunity to be accepted there, and whether he would be enough of an insider. But this is the...
It does say in paragraph 8, I've lived here for 18 years, since I was 7. I don't have any relations in Germany, and I don't speak the German language.
That's all.
I mean, what more could he have said?
He could have engaged with the points that the Secretary of State had made in the decision letter, addressed...
The State said, you seem to speak German. He says, I don't speak German.
Yeah.
I can't remember, does the Secretary of State speculate on whether he has family in Germany? He says, I don't have family in Germany.
Yeah. So the Secretary of State said, for the relevant purpose, that, 60% of population in Germany speaks English. So yes, he says that he cannot speak German language, provided no evidence as to why the inability to speak German presents a very significant obstacle.
How could he have dealt with that? I mean, he says, I don't know Germany, so I'm not in a position to give details about how difficult it is to get by without speaking German in Germany.
Well, perhaps not this case. In another case, an applicant could have adduced objective evidence, for example, demonstrating that the Secretary of State had got it wrong, and objective evidence that people who are unable to speak German face some serious difficulties in finding way around in Germany. Not this case, but another case, a person can say that, well, I have, say, mental health issues that impact on my ability to form relationships with other people. Or another case, a person may say that, well, I have health issues and I will not be able to work. And if I'm not able to work for X, Y, and Z reasons, I will not be able to access public funds. He says that he plays football in the country. Well, for these reasons, I cannot play football in Germany. But this was the appellant's evidence. Now, can I then turn to the first-tier tribunal's decision? This is page 79. Can I just take you straight to the relevant part of that decision, the part that deals with the very significant obstacles to integration. There's no dispute as to what is said about other limbs. So page 85, you see a heading, very significant obstacles to integration. And you have, of course, seen paragraphs 28 and 29. In my respectful submission, no matter how one reads those two paragraphs, the judge made 3 points, and then, in my respectful submission, repeated those points with in a different language. The first point the judge makes is that he has no ongoing social, family, or cultural connections with Germany. This is paragraph 26, line 6, that he has no ongoing social, family, or cultural connections with Germany. The judge repeats the point that he has no familiarity with German culture. The second point the judge makes is that he did not speak German. And not that that would make it impossible for him to live in Germany, and that it is likely to affect his ability to look for and obtain employment. This is middle of paragraph 28, line 12. It's likely to affect the ability to look for and obtain paid employment. And the third and final point is that he will have no sport on return. No sport on return. This is line 9, I think, of paragraph 28. If he returns to Germany, he will have no sport on return. His family members are in the UK and unlikely to be able to go with him. Again, I made 5 points as to the law. Make those 5 points by reference to the facts of this case. The first point that I make is that there is a failure, in my respectful submission, by the judge to appreciate that the threshold in section 117C4 is an elevated threshold. The word very has a role to play. This is what this court had said in Paveen.
So just pausing there, Parveen says elevated threshold, but also says, well, apply the language, very significant obstacles. It's not any obstacles, it's very significant obstacles.
Yes.
And we find recurring through this, the judge referring to very significant obstacles. So how do we know he was applying the wrong threshold?
Now, the two separate points that I make. The first point, before I make it, I would acknowledge on its own wouldn't be enough to impugn this decision. And that point is that there is no reference to Parveen in the judge's decision or to the way in which the test was identified in that judgment. But that alone, as I said, is not enough to show an error of law. The submission that I make is that the judge, this is the second point, the judge in substance failed to apply that test. The judge did not, the judge, as I said, noted that, for example, inability to speak German is likely to affect the ability, but did not ask herself as to whether the obstacles that she has identified would prevent or seriously inhibit integration into Germany. So it's not enough in my submission for the judge to simply say that, well, the inability to speak English is likely to affect his ability to look for employment without then considering as to how that would prevent or inhibit, seriously inhibit his integration into Germany.
So, really, what it boils down to, Mr. Malik, is you're submitting that she's identified the obstacles, that she hasn't then looked at how those obstacles are going to impact on him in practical terms.
With the relevant test in mind.
In mind.
Yes. That is the first. With the elevated test in mind. That's the first point. The second point is that the judge at paragraph 30 says that she has received assistance from this court's judgment in Kamara. Of course, Kamara is not merely something that assists a judge. It's a binding authority that the judge is obliged to apply. But I, of course, don't say that that alone amounts to an error of law. But I do submit that there is, in substance, a failure, complete failure, to apply the test in Kamara at paragraph 14, the test I've taken you to. The judge has not considered whether Mr. Bonsu will be enough of an insider in terms of understanding how life in Germany is carried out, the words that Lord Justice Sales used. Second, the judge has not considered whether the appellant, whether Mr. Bonsu lacks a capacity to participate in that life. So it's not enough for the judge to say that, well, he's likely to, inability to speak English is likely to affect employment. But why he does not have capacity to participate in that life is the question. And third, the judge has not considered whether Mr. Bonsu will have a reasonable opportunity to be accepted there and to be able to operate on a day-to-day basis. But inability to find employment is not enough. Reasonable opportunity, the words the Lord Justice Sales used, to be accepted there, to be applied, to be able to operate on a day-to-day basis. Now, the appellant, as my Lord pointed out, Mr. Bonsu does not have family in Germany. But again, invite Lady Milords to consider what Lord Justice Sales said at paragraph 14 of Kamara, and to build up within a reasonable time a variety of human relationships to give substance to a person's private and family life. So there's no family there. But why is it that he is unable within a reasonable time to build new relationships? That is the test. So these are the four matters that the judge in my submission has simply failed to consider. There is therefore, in my respective submission, an error in approach. The judge has not applied the test in Kamara, has not applied that test as a binding authority.
You said your first of your 4 points was the judge had not considered whether the appellant will be enough of an insider. It does say more than once that he has no ongoing familiarity with German or German culture. It says that in 28.
Yes.
29 says isolated from German culture. And I think he says it again somewhere.
Yeah.
Why is that not a consideration of whether he's an insider? What's wrong with that as a consideration?
Well, I do say, and this really is my third point as to why that point reflects a separate error of law. But to answer my Lord's point, it's perfectly possible for a person to have no immediate links to a country of return, but yet that person may well be enough of an insider to know how, to have an understanding as to how life in that society is carried out. So enough of an insider to know how the life in that society is carried out is the test.
Well, I understand that, but he says it's a country he has no familiarity with. That's the end of 28.
Yeah.
And I myself would have thought that if you say someone has no familiarity with a country or its culture,
yeah,
that is addressing the question whether they're an insider or not enough of an insider.
I completely understand the point, and when I was addressing you on the law, I made a submission with respect that phrase had generated some controversy, and this precisely was the point that this court dealt with head on in AS Iran.
You've got no ties there, therefore you're not an insider.
Yes. So the appellants following Kamara resisting deportation would make that point. It's not unusual to see foreign criminals who are facing deportation to say that, well, I've been in this country for many years, I haven't been to my country for 10, 20 years, most of my life. You only get to limb 3 if you demonstrate that you have been in this country for more than half of your life. So this is the point that an appellant would make. But what this court said in AS Iran is that if that is enough, then that could be seen as defeating the purpose of the scheme.
I understand that, but not having any ties with the country, I don't have any relatives there, I don't have any friends there, I don't know anybody there. It's not quite the same as not having any familiarity with the country's culture. And this appellant left Germany at the age of 7. And the judge has found that he has no familiarity with the country. That's a slightly different point from saying he doesn't have any friends or family there, or other links with it.
Yes.
It's saying he doesn't understand how Germany works. Now, you want to say, well, Germany doesn't work very differently from the way the UK works. It's all part of a common European inheritance. But that seems to me to be a sort of factual. You're taking issue with the judge's conclusion on the facts rather than saying he hasn't addressed the question as to whether he's an insider or not. That's how I see it. But I
see.
I've misunderstood.
No, I do make the submission that the judge has not directed herself as to the 4 points that I've identified. There's no, for example, self-direction that the judge was considering whether Mr. Bonsu is enough of an insider in understanding how the life in that society is carried out. So if for example, a person comes to this country as a child from, say, Afghanistan or Iraq and lives here all his life, that person has no familiarity with how life is carried out in Afghanistan. And it could be seen as to how that person can be said not to be enough of an insider as to how life in that country is carried out. But Germany is in a different position. This really is the third point. But I do say with respect that there is misdirection. But assuming that my lord is not with me on this, and my lord, you take the view that, well, there's no misdirection. The judge considered whether Mr. Bonsu will be enough of an insider. But what about the three other points that I made? Whether he had capacity to participate, whether there is reasonable opportunity to be accepted there, and whether within a reasonable time he is able to build new relationships.
Well, the same sentence, I suppose, is the one that would be relied on. I'm not satisfied he'd be in a position to find work to be able to support himself, and I am satisfied that in his particular circumstances he would face very significant obstacles in reintegrating to a country that he's had no connection with since a very young age.
So, lady, for the purpose of my second point, you have my submission that there is. I mean, of course, I seek to impugn that very sentence.
Yeah.
And that finding, it's really point 3 and point 4.
Yeah.
But you have my primary submission that there is substance. There is in substance a failure to apply Kamara. Now, just moving on to the third point. This is where the judge says that Mr. Bonsu has no social or cultural connection with Germany. He has no familiarity, the judge says, with German culture. Now, the problem, in my respective submission, with that approach is that it is inconsistent with Ben Buga that I've taken you to. Now, when it comes to culture, what that word reflects is core values, ideas, customs, and social behavior. Both the UK and Germany, and indeed other members of European Union, this really is the point of principle, have a shared culture of democracy, rule of law, respect for human rights and civil liberties. So in comparing the culture of UK with that of Germany, the judge, in my submission, omitted entirely these cultural considerations.
He does say he's taken into account, or she does say that she's taken into account that Germany is a European country.
Yes, but no more than that. The judge says that the appellant has no familiarity with German culture. That finding in my submission simply ignores the similarities that I've sought to identify in the two cultures. The fundamental point being that there is no substantial or material difference between the culture of the UK and the culture of Germany, so far as this particular provision is concerned.
Is that something we can take judicial notice of? It's just something you invite us to.
What I invite lady and lords, to say is that when considering two cultures, what the decision maker should take into account is whether there are common themes of democracy, rule of law, respect for human rights and civil liberties. This court said core values, ideas, customs, and social behavior. So I'm not asking the court to go beyond and to take a judicial notice of how life is carried out, in particular in Germany. But so far as these themes are concerned, there is no substantial difference between the UK and Germany, or indeed with any other European state. Now, there ought to be a recognition of that in my submission by the decision maker, and there is a failure to recognize that. And I do also submit that even if there is no error in approach as such, it was just not open to the judge to say that the appellant, Mr. Bonsu, has no familiarity with German culture. If you approach culture in that broader sense as this court had approached in Nugee. So the finding is perverse, was not open to the judge. Social integration refers to membership of clubs, etc. Clubs, societies, workplace, place of study.
Are you going to make the point that the Germans are mad about football?
So the appellant plays football in the UK. Well, that's the only. Well, if there is something
to a reasonably high level, because he has aspirations of being a pro.
Yes, I mean, if there is something that the court can take judicial notice of, that is that fact that the Germans do love football as people in this country. Is obviously able to play football in Germany. That's the only point as to his social life that he made. Just moving on to my fourth point, and this addresses the point that is put to me that, well, although the judge hasn't really said that Mr. Bonsu is enough of an insider, well, this is really what the judge has done. Well, if Milady and Lords take the view that this is what this judge has really done, then in my submission, the conclusion is perverse and the reasons are inadequate. Now, this court in AS Iran has said that in considering whether a person is enough of an insider, you look not only, you don't look simply on that person's ties or links with the country of return. You look at the generic factors. Now, the generic factors here are that 60% of Germans speak English.
To some degree.
Sorry?
They don't all necessarily speak it fluently.
No. But if you're being deported to a country where 60% of population speaks English, then you are, in my respective submission, a person who would know how to go about your life. You will receive a reasonable opportunity, the phrase that Lord Sales used, to be accepted there. I mean, compare this with a case where a person who only speaks English is being deported to Afghanistan. That person can say that, well, I will not be accepted in that country. Reasonable opportunity to be accepted there. 60% of population speaks English, a reasonable opportunity to develop new relationships.
I'm not sure it helps very much, but are you in danger of failing to distinguish between reasonable opportunity to be understood and reasonable opportunity to be accepted? I mean, the fact that lots of people speak English will help you to understand and to be understood, but it doesn't necessarily follow that all those people will accept you in a different sense unless you speak German.
Wow. We're talking about Germany here. There has to be an element of reality to this.
Yeah.
The truth of the matter is, if you speak English in Germany, I wouldn't think the Germans are going to hold that against you. Not now.
Yeah.
Anyway,
Now,
back in the 1940s.
yes. Now, the point that Milady makes, I respectfully adopt, and that is based on the objective evidence. And I've taken you to the objective evidence that that the Germans teach English at school and how rigorously they teach.
But also, you've got the objective evidence that the powers that be, which I haven't spotted, and I'm grateful to you for showing it to me, that the certainly in Dusseldorf, I think the Secretary of State says that the Dusseldorf authorities, if you were applying for benefits or help with getting work or something of that nature, will understand English and will help you in your language, and that seems to me to be quite a significant factor.
Yes, I do respectfully make that point, but I do make a further point. I mean, let's assume that a person has no familiarity whatsoever with the language, but that alone is not enough. I mean, why is it that that person is unable to learn the language? Learn the language, and then in a reasonable time develop relationships. Why that person will not have capacity to participate. Now, the other generic factors to consider are that the judge makes the point that, well, he is unable to speak English and that is likely to affect his ability to find work. We'll assume that that is right. But what about the fact that Germany is a first world country? It provides top-tier healthcare and social assistance to its citizens. Mr. Burns, who is a citizen of Germany, he, as a matter of law, has an entitlement to guaranteed minimum resources, the objective evidence, the booklet that I've referred you to. There are different benefits depending on personal situation, age, and life situation. Unemployed people who are not fit to work but who are in need may apply for job seeker allowance. People who cannot or not sufficiently able to live on wages they earn are classified as in need for assistance. This comes from the booklet, this comes from the objective evidence.
Is one of the points you make, Mr. Malik, that the first-tier judge just doesn't address that at all?
No. So the judge says at paragraph 28 that, well, inability to speak English is likely to affect the ability to look for employment.
But he also says that Mr. Bonsu would be entitled to benefits.
Yes, at paragraph 29. But that's all really. So the focus of my challenge so far as this particular point is concerned, or this particular limb of the point is concerned, if look at paragraph 28, if he returns to Germany, he will have no support on return. Well, he will have support, but even if he is not able to work, even if there are no other family members, he will have the support of the state. It's not enough simply to say that, well, he would be entitled to benefits. Judge says, well, yes, he would be entitled to benefits. This is paragraph 29, last 4 paragraphs. But overall, I'm satisfied that he would face very significant obstacles. Well, that, in my submission, is a perverse finding. If not perverse, then it is at least inadequately reasoned. Well, if a person has an entitlement in law to receive support on return, then cannot be said that person will have no support. So there is a failure by the judge in my submission to direct herself to these relevant generic factors. If you take the view that there is enough self-direction, then the reasoning is inadequate, the conclusions are perverse. The final point that I make is that there is a failure by the judge to properly consider or engage with the circumstances of his offending and Mr. Bounce's character. I've showed you the sentencing remarks. So he is a person who, as I said, who knows how to deal with the suppliers, how to get a product, sell it on street, how to conceal items. And that, in my submission, shows robustness of character. And he knows how to work in challenging circumstances. Not only that, he has completed GCSEs and A-levels in the country. He was in employment before, worked in prison. So no consideration, in my respectful submission, of these matters, the robustness of a person's character based on his offending, his education, his previous employment, and his work in prison. And that too is an error of law.
There's
Now,
mention of his education at 23, and there's mention of the work in prison at the end of 26. He's engaged in bricklaying and construction education courses which will assist him in reintegrating back into society on release.
yes. So those are paragraphs where the judge is considering a different limb of section 117C. If you look at
Yes.
page 83. So the second limb is whether there is social or cultural integration in the UK.
Yes.
And the judge is making all those points to support her conclusion that there is social and cultural integration in the UK, but then ignoring the points completely when it comes to the fact that those points show the robustness of his character to go about in Germany. For these reasons, I respectfully submit that the first-tier tribunal's decision is wrong in law, and it was not open to the upper tribunal to uphold it. Now, well, this court has repeatedly said that in an appeal of this sort, the direct question for the court is whether there is an error of law in the first-tier tribunal's decision. There can only be one right answer. If you are persuaded that there is an error of law, that means that the upper tribunal was wrong. If you are not persuaded that there is an error of law, that decision stands. So whatever the upper tribunal has said makes no difference. So I will not take you to the upper tribunal's decision at this stage. But you have seen the upper tribunal's decision in a sense that the upper tribunal said that the decision was open to the judge. But for these 5 reasons, it wasn't. So unless I can assist you any further, these are my submissions in opening.
Thank you very much. I think we'll rise for a moment just to see where we are.
Just to remind parties, the stream will continue while the constitutes.
Good to see you. Yeah.
The stream does continue. Okay.
Let's see the same. there is an important point here, about the European culture. Yes, quite an important point, particularly after Brexit.
Yeah.
As to how to approach.
Good. Much one idea. Fine.
Let's see.
So we're going to make it away for 1 o'clock, do you think?
Seems that Mr.
But
Stedman
we've
is
lost Mr. Stedman.
Oh,
I mean, we're just about to ask to hear from him.
My lord, my lady, counsel doesn't appear to be in the corridor. I'll see if he's.
He went to the bathroom.
Thank you.
I think we'll just stay here for a moment because Mr. Stedman will be back shortly, won't he?
Yes, I do hope so.
My apologies, my lord.
No apology needed. So, Mr. Stedman, when you're ready.
Grateful, my lord, and grateful to my learned friends' exposition of the law, in particular in relation to Kamara, and for my lady for noting striking similarities in that case. Very easy for practitioners to get caught away with the summary, but no, that's quite right. The facts, apart from the fact that he was due to be deported to Sierra Leone, which obviously...
well, that is quite a significant difference,
Indeed.
especially when there was Ebola in the country at the time.
Indeed, my lady. And it's always going to be a significant point, but beyond that, the other facts seem to be the same. My learned friend also took you to, described in some detail when he was pursuing the robustness point, if I can put it that way, describing the offence. And that always leads, inevitably, when the listener is listening, to really a visceral reaction, because crimes are not nice to listen to. And generally speaking, there seems, to my reading, nothing to prevent a court from considering robustness. And I express it in that way, nothing to prevent a court. But of course, it has its dangers. One can see how a young lad getting involved in crime, selling drugs on the street, is going to have to be a whole raft of. It's going to have a whole range of different characteristics: robustness, assertiveness.
If it was just the low-level street dealing that amounted to the first-level offence, that would be a good point, because one sees it time and time again that youngsters get sucked into whatever culture. They either get into drug debts or they get into gambling debts, whatever, and they're then low level down the food chain, what we call category 3 drug dealing. Absolutely. If that was his only offending, what bothers me, I'll lay my cards on the table, is the fact that he has got scales in the car. He's got all the other accoutrements that suggest, and he is described by the judge as a trusted lieutenant. So he goes into significant role, which is upper bracket, And that shows somewhere further up the organisation than just being low-level fodder for street dealing.
That's absolutely right, my lady, and that is and was reflected quite
In the
rightly
sentence.
in the length of the sentence, and statute provides for that.
Mm.
So no, I take that on board entirely. My reservation or hesitation, I should say, towards the use of the word robustness is because, of course, there are some awful crimes which have even more of a direct impact on the victims. For example, serious sexual crimes, which have nothing to do with robustness, in which, if that was followed through as a general principle, would mean that an individual who had perpetrated a sexual crime would be less likely potentially to be deported because of their individual characteristics. And I'm not talking about them having mental health issues, but I'm talking about just in the ordinary run of things. So there's something to be said for it, but also with a great deal of caution.
But where do you say that the judge, the first-tier tribunal judge, deals with the question of robustness? If she deals with it at all. Does she say, you know, and is there anything in this that you would point to that show that she's considered what sort of work he might go for, what sort of steps he might be taking, whether he's the sort of young man who's got the initiative? Or...
Yes, in my, from memory, my lady, and I will come back to it. One point that the first-tier judge does make is that there is the possibility that the criminal convictions, just like in this country, would have an impact on employability. So that would be across the EU in much the same way. And I will come back to that. I just wanted to address briefly, if I may, the familiarity point, because that's interesting, and I don't want to dwell on it, but simply to say, I would propose that familiarity means something like, whilst not directly familiar with language, society, structures, what's on TV, a whole range of things that would make someone familiar, quite often through family, part and parcel of the same thing. But also, I think importantly, familiarity would require a return to the country. So let's say, for example, and that wasn't the case here, but let's say, for example, that Mr. Ackom had gone back, let's say once or twice, even if not establishing links during that time, that would increase familiarity in the same way as a child here may be familiar with, I don't know, going to the coast, going to Alton Towers, or whatever the case may be. So the point was here, there's no challenge to it, is that there's no familiarity. And one further point was raised, and I think my learned friend clarified it clearly. This 1174 and the three limbs are a shortcut, essentially, and it's a shortcut for this shortcut provided by statute to medium offenders, irrespective of the type of crime, and therefore, if a potential deportee is able to satisfy those three tests, that then becomes dispositive of their Article 8 appeal, which will be in their favour.
It's reflecting the European jurisprudence on Article 8 in the rules.
Yes, I mean
What it's there for. It's not a shortcut. It's a reflection of the balancing exercise which this country has to carry out under Article 8, as reflected in all of the rules before, the case law before.
My lady, the reason I use that particular word with respect is because it was used by the Supreme Court, I believe, in HA, and it's there because subsection 4 does not require any balancing exercise to be taken out. So Article 8 is replete with balancing exercises left, right, and centre. Within this, essentially, the Secretary of State says, I position myself and position proportionality at this mark.
I think it's Parliament rather than the Secretary of State,
Yeah.
isn't it?
I beg your pardon, my lord. Yeah, absolutely right. But it's Parliament's intention that, and I think that's why in HA the Supreme Court described it as a shortcut. Of course, for more serious offences, and I think they described that as a stop valve, the court would need to undertake a balancing exercise. And I think that was the criticism initially when the grounds were advanced, that the first-tier tribunal judge didn't really embark on a sufficient balancing exercise. And
Depends what you're balancing. One's not dealing with a balancing exercise in the Article 8 sense of proportionality, factors for and factors against, because you start from the starting point that deportation is conducive to the public good, and then if you tick the 3 boxes, then it's outweighed. So there's no balancing exercise in that sense. But that doesn't mean to say that in working out whether or not one of those limbs is satisfied, you're not taking into account, whether you call it balancing or not, all relevant factors. And there may involve a weighing of factors, because there may be advantages and there may be disadvantages, which you have to put together in order to work out where you come out.
My lady, I couldn't agree more. I understand, and that's absolutely correct. It's got to be the case. But I was thinking more generally in terms of a categoric balancing exercise, which would be applicable under subsection 6.
As I understand it, it's common ground that if you tick the 3 limbs of subsection 4, you don't then go on and say, now I've put that in the scales. On one side, on the other side, I've put the seriousness of this particular offending.
That's correct.
You tick the 3 boxes.
My lord, you don't, but you can. And the reason you would proceed is because there are factual scenarios, factual matrices, that's the word, where an individual fails under either exception 1 or 2, but conversely is able to satisfy the court that there are very exceptional circumstances, or over and above, or circumstances over and above those within the exceptions, and it's rather hard to try and work out what they might be. But I cannot, for my part, see that within a private life context that would emerge, but perhaps within a family life context.
You don't suggest that's. We don't need to consider that.
We don't. You don't.
The only thing we need to consider is
correct.
The conclusion there were very significant obstacles.
Indeed.
Was a justifiable line.
Indeed, my lord. Thank you. Yes, because that would then be the end of the matter. I was also mindful of the observation of Lord Justice Arnold in granting permission, and this has just been highlighted in terms of the important point of practice or principle. And I suppose I agree with my learned friend that it really must be that, well, hang on, we're dealing with Germany. It's just Germany. It's not, a million miles away, and really a completely different reality. So I would accept that that's important. And later, I will say that that's, and this supports what the Secretary of State is saying. That I would agree that that's always important. But I'll come on to that in just a moment. My lords, my lady, I propose principles as an assistance to the court, and I propose these as non-controversial principles relating to medium offending under section 1174, and in particular limb 3, which is applicable here, which is very significant obstacles to integration. And that is, my submission, a unitary question. It is not binary. It is not very significant obstacles and then breaking down what integration means. It's very clearly a unitary question which is asked, which is, are there very significant obstacles exclusively to integration? That seems to be
it's a 2-stage process. Are there obstacles to integration? How significant are they? Are they very significant? So first you start by identifying what the obstacles are. Then you ask yourself a value judgment as to whether they're very significant.
Yes, but within that first question, my lady, would be, are there very significant obstacles? I would add to that to integration, because there is always that first part is always linked to integration.
Yes.
Yeah, and of course integration is very broad, multi-dimensional concept anyway. So if I may just run through these, I won't, in light of my friend gone through Kamara and various other cases, I won't need to trouble the court at any great length. But I thought these may be of some assistance. So in the first place, and these are not necessarily exhaustive, and the logical sequence is my logical sequence, but it may be of assistance. So initially, number one, the court must undertake a broad evaluative approach to very significant obstacles. That's established, and that's been confirmed over the last 7-8 years. No dispute to that. The second point, so again, even if it's not mentioned, judge that right, I'm taking a broad evaluative approach, and then does so to the best of their ability, is Kamara compliant, if I can use that phrase. Excuse me, just one. So that's in the application of Kamara. The second point, again, cannot be controversial, that each case demands a very careful, fact-specific analysis. Again, that seems to be a principle from which no derogation can really be permitted. But of course, in any Article 8 case, that's always going to take on a really central, crucial role, because you're dealing with personalities, individuals, and all of those things may or may not be relevant. So that I say has to be done. And if it's not done, that's problematic. But I add to that at this stage that individual assessment of the potential deportee has to be done within the context of the receiving state. And I'll come to how that ties up together. So it is not just she is young, healthy, has mental health problems, can speak language. It has to be done within the context of the receiving state. I think, my lady, you mentioned this. Third point, when approaching the task, that the courts must make a realistic or real life assessment. Equally, that could be termed as a practical assessment, but it's an assessment of life on the ground for the individual. So really the court here hypothesizing on the realities of a future existence. So one could see that in this case, for example, and I hope I'm not shooting myself in the foot in any way, but if Mr. Ackom enjoys playing football, well, we can imagine him. Could he be playing football in a team somewhere in Germany? I mean, he's obviously too late now for the professional route, but you know, we can visualize the possibilities. So that would be one positive aspect of life in Germany for him. So in terms of number two, it's that practical assessment, and just reference to the case of NC. This is 144 of the authorities bundle. This court said this at paragraph 26. The court will consider the likely reality for the appellant resuming her life in her home country must be considered given her subjective fear and the availability of support. And
Sorry,
then,
which paragraph are you on?
so I'm now on 28 and 29. They're short paragraphs.
I think what you were reading from was from 26, wasn't it?
It was, my lord, yes.
Thank you.
So 28, the first-tier tribunal should have considered all of this evidence as part of its evaluation of the appellant's case, its focus should have been on the likely reality of the appellant's day-to-day life if returned. And then, I'm not sure to what extent I've paraphrased 29, but I think it's very short, and my lords and ladies can read it there, granting the approach stating the approach to be real practical difficulties. So it's a really more than holistic, it's holistic applied to the realities and the practicalities of life. So these cases really call on the tribunals to dig down into the evidence and to ask questions, because quite often neither the representatives nor the Secretary of State's representative actually do dig down, and then problems arise later on, and to an extent that may have happened here. Of course, no story is going to be complete. Court specialist tribunals operate within time limits, they operate within evidential constraints, and so on. I want to next move to consider the term very significant obstacles. And my learned friend, who I think has some very direct experience in Parveen, if I'm not mistaken. So I'm happy to stand corrected by saying this, that the courts do pay more than lip service to Tribalan, where the concept of elevated risk, an elevated threshold was raised, and in Parveen, the court do seem to go along with that, well, they don't resile from it in any way, but what they do is two very interesting things in Parveen, and this is all at paragraph 9. This is 150 of the appellant's bundle. And it's this, that not only do they confirm that the bar is a high one, elevated, very significant, but what they also do is the Court of Appeal actually say, well, here's a low bar and that won't do. And so really, it does give the impression or the understanding that something that's in between, so one factor that's not so strong, but that's in between, may amount to very significant obstacles, and they go on to state actually, and I think this is, in my submission, absolutely crucial. It is not about isolating and finding one serious factor or two serious factors, but actually Parveen is authority for the proposition that an accumulation of obstacles, each not very significant in their own right, I appreciate I've read that with emphasis as if it was a quote, but I've just paraphrased, can amount to very significant obstacles, and that's in 9 of Parveen. So again, back to this broad approach where the judge says, well, these factors in isolation, they don't amount to much, but cumulatively taken together, I can see that they meet the threshold test, which is a high one, and I accept that. It's just
where do you get the each not very significant in their own right?
yeah,
You say it's not a quotation. Which bit are you paraphrasing?
I think I'd need to just check paragraph 9. It may not necessarily.
The last sentence.
So initially at paragraph 9, the Court of Appeal do not have any concerns about confirming the very significant, the elevated test. And then they go on yes, then it goes on to say, I am not sure that saying that mere hardship or difficulty or hurdles, because that's, my lords, that's the baseline. The baseline is there will always be hurdles. But then goes on to say, even if multiplied, will not generally suffice, adds anything of substance. So the way I read that, maybe that's wrong, but it's clear to me from that that is saying it is possible that other factors alone, when combined and put together.
No, that's not what Lord Justice Underhill means. Sorry, with respect, that's not what he's meaning. What he's saying is that when the Upper Tribunal Presidential Panel in Tribune said that mere hardship, mere difficulty, mere hurdles, mere upheaval, etc., even where multiplied, will generally be insignificant. All that Lord Justice Underhill there is saying is, I don't think that adds anything of substance to the fact that it's an elevated test. He's not saying they can. And the key sentence in Parveen is the last one. The task of the tribunal is to assess the obstacles, whether characterised as hardship or difficulty, and decide whether they regard them as very significant.
Yes, I'm grateful, my lady, and yes, I would agree in terms of that, and I've actually cited that at the end of my submissions. But yes, but when one reads that last sentence, that would seem to imply, in my respectful submission, that even where there individual circumstances, individual obstacles or hardships are not great in themselves, that together, by combination, there's nothing to stop, in other words, a tribunal from reaching the conclusion that a number of features of a particular case, whether based on the country circumstances or based on the individual characteristics and idiosyncrasies of an applicant, could not amount to very significant obstacles. But that must be the case, because essentially it's the job of the tribunal to bring together all of that evidence and then make an evaluation of it. So, but yes. So in the first place, yes, the term "very" in itself connotes an elevated threshold. So I don't need to say anything more about that.
So that's your fourth principle.
Yes. The fifth is this, that there is a distinction to be drawn in all. This is, as I say, a general principle I propose, that there is a distinction to be drawn between cases where, on the one hand, the individual has what I would describe as a working memory or experience, live experience of the receiving country. And this is irrespective of the level of their integration into the UK. So they are integrated in the UK. We work on that assumption that that's the same as the facts in this case. But the individual has working memory or experience on the one hand, and on the other, individuals who have no meaningful ties or familiarity or experience of it. So I mean really something more than a distant memory of attending a play school. I mean something that would be generated, would have been kept within the mind.
Those are rare cases. I mean, it's a case of somebody who came over here as a student.
It's going to be age.
Yeah.
It's going to be age, yeah. So that's again a factual, very obvious, common sense point. So that is the distinction there, and of course the reason being because of the impact on the individual and their prospects of integrating. And I just want to expand, if I may, on this a little bit, because it does come back to the Germany point and does touch on the issue of language. So on the one hand, where the individual retains a connection with their country of origin, so that could be that they speak the language, they have personal experience, or they've been to school in the country, notwithstanding that subsequently they've come to this country and integrated, that is also always going to be relevant.
What age do children start school in Germany?
Kindergarten.
Just 6 or 7. Yeah, that's just. I would need to.
I think they go to kindergarten earlier than that. It's much the same
I
as in
think primary school's a little bit later.
primary schools later.
Sorry, and in fact I had meant to move on to the next point, which is the 6th point, which is tied to this, which is there's also a distinction to be drawn based on the destination country. So that seems to be point 5, the individual's experience of it, or whether they've retained any links in their mind with their family in any other way. In this case, Germany, but no ties, no familiarity, no links. And
We know that no ties, no links, etc., isn't good enough in itself.
yeah, so just in terms of a general principle, then the destination country is always going to be relevant. That's my primary submission, because there's a very obvious difference. Returning an individual to an unstable, deprived country, versus an individual who's been returned to an advanced, westernised country such as Germany. And I say that even where the individual has no familiarity with it, right? So I mean that's always there. So this, in my submission, is an objective assessment. It's as simple as that. It's a simple factual assessment. You're not going back to your home country, which is essentially a third world country. And of course, the reason for this is very obvious, because the context then is questions such as, would that European country be able to provide basic levels of state assistance? Would it be able to cater to, provide care for those who are vulnerable, and to protect them from destitution, to protect them as best they can from crime, etc. So in terms of that objective assessment, that always has to be present. And of course, I think the next point really is, before I get to that, I can certainly say that there's so much interplay, and which is why you can't restate the test of a broad evaluative judgment enough times, because you're going to have an infinite variety of individuals before tribunals who have different issues. One, let's say, comes from Angola, doesn't have mental health problems, but has connections.
But I think all of this is a given.
Yes,
are we nearing the end of your list of principles, and are we going to get to the actual meat of the case?
My lady, yes, of course. I will move on as soon as possible, and I accept they are given. So just to summarise that then, the conclusion is that the court must, in each and every case, when it's breaking down the facts, when it's looking at the history and the background, that it must address its mind to both subjective and objective or generic factors. So the court in NC said this very clearly, set it out very clearly. That's at paragraph 25. I won't read it. I don't need to take up the time of the court, but it's very clear there that the court, I can just read the last bit. The test is not subjective, say the court. Perhaps that should have been purely subjective, but in the sense of it being limited to the appellant's own perception of the obstacles that extends to all aspects of the appellant's likely situation on return, including objective evidence. So I'll leave that point there. That's clearly understood by this court. And the eighth point is this, and this is, for the purposes of this appeal, perhaps the most important, and that is that the weight to be attributed to each factor, whether subjective or objective, cannot be prescribed by the courts or limited. And one can see that in paragraph 14 of Lord Justice Sales in Camara. It's quality, not because it's just withstood the test of time, but because it allows room for judicial decision making.
But what this all boils down to, just to cut to the chase, you say it's an evaluative judgment. You take into account all the relevant factors, and this court shouldn't interfere with it if it's within the reasonable range. That's what it boils down to, isn't it?
My lady, yes, it does.
And the question for us is, did the judge go wrong in the evaluative assessment in the ways that Mr. Malik has suggested that she did, or didn't she?
That is absolutely right, and I'm grateful, but I do just wish to make the point about weight, because that goes then to rationality. So the weight to be attributed to each factor is within the domain and remit of the judicial decision maker, and I just want to give a very simple example of that. Again, if an individual has vulnerabilities, physical, mental health problems, that will affect their employability in the destination country, then the destination country becomes the more important, and more weight is given to that. Equally, less weight is given where the country is unable to provide those services and care for the weak in society. My point really is that there's an infinite number of varieties based on the particular facts in a case. And in the Supreme Court in SC Jamaica, this is at page 203, really, in my view, is helpful and instructive, because and this they cite my learned friend's favourite word, robustness, because what the Supreme Court actually says is this: the robustness of the individual, even if a factor derived from the statement that an individual who commits crimes is robust, I want to just add my own thoughts to that.
Sorry, which paragraph are you in?
This is paragraph 107, my lord.
Yes.
I mean, I've made some comments on robust, and not really for me to comment on the Supreme Court, who seem to have taken on that concept. And as a concept, I can see why, but I've already made points on that. But even if the court proceeds on the basis that because of an individual's criminality, he is more assertive, he's toughened up, he's hardened. Yes, but in that case, the Supreme Court immediately overshadowed that reality with the reality that actually this was a man with, I think it was complex PTSD. In other words,
Each case, as you say, turns on its own factors, but with respect, I don't know that it's going to be of great assistance to us who look at cases about somebody who's been subject to torture. Your client hasn't been subject to torture. The real question is, did the FTT judge make this evaluative assessment in a way which was legal?
yes, but I noted from my learned friend's position, for example, that he made a number of references to robustness of the individual, and so I simply wanted to
say it's a balance.
Respond to those, and that it's a balance, and really to end then on H.A. Iraq, which is decision of the Supreme Court, and they say this, and it's very helpful and very instructive, given that the weight to be given to any relevant factor in the proportionality assessment, and they're talking about 117C6 here, but it applies just the same, will be a matter for the fact-finding tribunal. No definitive statement can be made as to what amount of weight should be given to any particular factor. It depends on the facts and circumstances. So essentially, in this case,
Just which paragraph are you on there?
that, my lord, is paragraph 58
Yeah.
of the Supreme Court decision. That's at
In
page
18.
115 of the bundle. So where my friend says, well, this is Germany, and that wasn't given. Well, essentially, the case, the Secretary of State's case is that it was Germany, and that the judge did not put enough weight on it. Well,
No, his case is this is Germany, and we don't see anything in the reasoning that's apart from one line which says this is Germany, it's another European country, that
Well, that's-
engages with why Germany is relevant.
I will go to that. I believe, my lady, that there was a bit more than that, in fact, but I will go to those now. So the background context, which has already been shared, is that Mr. Ackom is a Ghanaian of heritage and has been in Germany since 2005, up until 2005 when he was 7 and he came to the UK. There is acceptance that he has been strongly integrated into the UK. That is important. He's been educated here, qualified, and was working up until 5 months before the sentence. It is also a fact that he was previously of good character, good behaviour, and had strongly integrated into UK life and had been obedient to its laws. The OASIS assessment following the conviction, and that's dated the 1st of July 22, assessed him as being at low risk of offending.
Yeah. So did the OASIS assessment before we went out and reoffended.
I mean, there's that's the danger. I say with confusing a balancing exercise when you're looking at whether there are exceptions over and above. With this shortcut through the statute, which is provided by statute, which is essentially, if I may, just almost colloquially summarise it by saying that was horrible. That was nasty what you did. That's done damage to the public. But I can't say too much about it because the ultimate assessment of what you've done is reflected by the seriousness, is reflected in the length of the sentence.
No, the point I'm making is not that he's a nasty foreign criminal, to paraphrase, but that when one's looking at the question of ability to integrate or reintegrate, there are two ways it could go. Either he's set in his path and he's not going to pay respect, or he is going to be respectful of the laws because he's a changed character, he's reformed in prison, etc. And you've got an OASIS system which says that. Then the answer is, well, if he's going to be respectful of the laws of this country, he'd be equally respectful of the laws of Germany.
Well, my lady, if he's going to be equally respectful of the laws of this country, then that's great. But if he's not, he'll be deported. Because
we have a Diva Sealand problem here, don't we? If there's not a material change of circumstances and he commits another offence, then unless he gets more than 4 years for it, he'll be straight back to the First-tier Tribunal saying, well, another judge looked at exactly the same factors and found that there were very serious obstacles to his reintegration into Germany. That's why the Secretary of State is worried about this case, I suspect.
Well,
and I see Mr. Malik is nodding at me.
I don't know if that's the case. Then, well, then so be it. But the issue for him, for Mr. Ackom, who was successful in the First-tier Tribunal, was successful with the Upper Tribunal, who provided a very strong, clear, eloquent, and quite diligently prepared judgment, actually. Setting out the reasons. So,
first, the Upper Tribunal judgment is excellent. It's very well laid out, and it's no more than one would expect from Upper Tribunal Judge Smith.
Indeed.
But the fact is that we have to really concentrate on the First-tier Tribunal judgment. And just speaking for myself, it would help me enormously if you were to just address the substance of this appeal.
Yes. So
And help me as to why it is you say that the judge was justified in reaching the decision that she did, or it comes within the reasonable purview of rational decision making in the light of Mr. Malek's criticism.
my lady, I'm grateful for that. So dealing with that specifically then, I have already set out the background. That was background that was accepted and not challenged. So the facts are the facts. Facts are, as I'm not going to repeat them, but they led to the acceptance by the Secretary of State that Lim A was satisfied, namely that he'd been here for most of his life. So that tends to show a level of integration, but we won't know until we move on to B. Does he satisfy B? Yes, he's satisfied. He's strongly integrated. And of course, that integration is not just in terms of him as an independent man, but this is him as a boy in a family, a boy with brothers, a boy with a family home, a boy with all the problems and features of adolescence, etc. So he's integrated. So that's the context. The next context is that he's committed a very serious crime, and that puts him on the path to deportation in a very serious way. And remember, this is not the case where the Secretary of State says, and forgive me, I can't remember the exact wording, but a case which has been certified as bound to fail or without any merit. That's not the case here. This was a case which the Secretary of State deemed to be arguable. And then we go off to the Upper Tribunal, and I think that there would be...
We are only concerned with very significant obstacles, and we are concerned with the FTT's decision on very significant obstacles.
Not the Upper Tribunal.
So
No,
I suspect is not going to help us to look at the Upper Tribunal.
Oh, forgive me. No, I've literally going through the first tier, not the upper. Starting with the First-tier Tribunal, we say she applied Kamara. There can be some challenge to specific semantics, but actually before I get there, if I did actually mention in my skeleton argument that within the confines of time and time restraints of judges in the first tier, a decision does not have to be perfect, and it may not be perfect. It may not be perfect in a number of ways, may not have been drafted as well as a judge who has the time to draft carefully. It's repetitive for one thing. So there are criticisms, and I think that there would be in any random sample of decisions from the first tier. But main point being that the judge says she's has considered and applies Kamara. She recognises the following factual features of this case: that he has spent the majority of his childhood and entire family life in the UK. Those are two factors. 3, that his entire family live in the UK. So it's not a family life case, but it's part of the overall picture. That he has no family in Germany, that they have no connections in Germany, so that's friends, acquaintances, wider relatives. And he has no ongoing social, family or cultural connections. Much the same thing. I've said there's some repetition. He does not speak German. Okay, that's a fact. But then, and this is interesting. So acknowledging that as a fact, giving it weight, the judge then goes on to say, whilst there may be many people who speak English in Germany, he will be returning with a criminal conviction and without the ability to speak German, which I find is likely to affect his ability to look for and obtain paid employment in Germany. Now, I don't see that there's been any challenge to what seems to be nothing more than a common sense hypothesis of what would happen to this individual on return. If you don't speak German and you have criminal convictions, it's going to take time. And of course, time is the important feature, because as we know from Lord Justice Sales as he was, paragraph 14 of Kamara, and I'll find that in just a moment, but that, of course, uses the words within a reasonable time. And so so clearly the judge thought that it wasn't a reasonable time. Now,
Where did you get that from?
So my point is that this issue of not speaking German was never put to. This issue of the Mr. Ackom learning to speak German was never put to him. That's not.
It couldn't be. He couldn't be cross-examined. He was in prison at the time. He'd been moved into another prison. The representative of the Secretary of State asked for a German and didn't get it. It couldn't be put to him.
Yes, but it's accepted. It's accepted that he does not speak German, and I would accept on his behalf that he has sufficient acumen and intellect to be able to speak German. I'm not going to say that he doesn't. I think that would just be an obvious point to make. However, my point is that in relation to Kamara, the court is looking at an individual's capacity to do a range of things, a capacity essentially to integrate. Part of integration is speaking language. My point is, it's all very well saying, yes, you can go and learn German. I mean, some people have different capacities. I can't speak a word of German. If I was going to try, I reckon within about a year, I would be able to have a fairly straightforward conversation and get on and go and do some shopping in Germany. I accept that. We don't know what the case is for Mr. Ackom, but even if he is, maybe not prolific, but able and adept to speak language, it will take time. And that is time to learn a language, not just in relation to employability, but what Lord Justice Sales refers to as the need. The need as a human being, functioning society, to be able to integrate and have relationships with other people. So
60% of the population speak English to some extent. Then his inability to speak German is going to be some obstacle. And it may be some obstacle to his getting work, as indeed may his criminal background.
My lady, yes.
Why is he not going to be able to develop social relationships with other people who speak English in Germany?
Well, within a reasonable time, number one. But number two, that may well be the case. And it may well be that the majority of tribunals working on the same facts would have said, well, we think it's likely, or I think it's likely that he will be able to integrate. This judge found that would cause an immediate problem, because of course it would immediately cause him a problem not speaking the language. It would immediately cause him a difficulty. It would immediately be extremely annoying, prevent him from doing so many things he wants to do, bearing in mind he's got no support structure there at all. But my point is not so much that, but my point is the conclusion reached by the first-tier tribunal judge, just because it was different to that, or didn't set out specifically when she, for example, thought he may be able to learn German, does not make it irrational. I mean, quite frankly,
the point is it's a reasons challenge as well. I mean, we've got, on the one hand, paragraph 26, he's engaged in bricklaying and construction education courses, which will assist him in reintegrating back into society. And then we've got, I'm not satisfied he'd be in a position to find work to be able to support himself because he can't speak German. Well, I wonder how many people speak German on a German building site.
But also, just to bear in mind and to go back to that point, it's within a reasonable time. And it's not just work. With respect, it is in order to foster relationships, to develop a social presence, to develop relationships which have meaning and give substance to life. So he would have to. I mean, it's the law, and yes, it maybe is a bit liberal, but there it is. The courts in this country have made set out the law which respects and gives weight to an individual having substance in their life and not just getting by. You know, is he going to be destitute? No, not in Germany. Send him back to Ghana, maybe for a much longer period at least. But what is the practical realities for him in Germany? Well, one, complete isolation from everyone here. That's not part of the test, but it's a reality.
What about social media? What about telephone?
No, I didn't bring in those things as part of it because the assessment is forward.
You know, don't exaggerate, please. I mean, complete isolation from everybody here is a little bit high, isn't it? His family are all here. He'd be in Germany.
If you are physically present with your family until your early 20s, there will be, and you do not want to be separated from them, then that is going to have some impact. I can't see that could possibly be a very serious impact. But my point is that he will be landed in a country where he has no social ties, connections, family, and really it's about, does he have any sufficient ties which will enable him to go through that initial transitional period, because it's that initial time where he's got no one. Yes, he's got FaceTime for his family here, but it's the context of real life relationships.
We know that the lack of ties in the country of destination is not enough to amount to be a very significant obstacle.
No, but it's a factor, my lady.
It's a factor?
Yes, factor that the court can give weight to. And I think the challenge is that essentially, ultimately, the challenge by the Secretary of State is, we don't like this one because he's going back to Germany. Why not? What's the problem? That's the essential point. I say, well, yes, in part I agree with that. I agree with the fact that there's a huge difference between going back to Germany, where some people speak English. But even apart from the language issue, it's not so much the language issue, I would say, but the focus has to be on, and I'm making the Secretary of State's point here, but essentially the fact that there are people and there are organisations who care and will not let you live on the street, will not let you be destitute. And so it's that level of provision associated with first world countries that makes all the difference. So ultimately, if then a child who's lived here all of his life, since the age of 7, who now faces being separated from his family, going to a country where he has no links whatsoever, no societal links, family links, ties, work, and doesn't speak the language, although I accept some people in Germany speak the language, whatever proportion that may be, could that amount to very significant obstacles when taken together? And I'm just looking through the list. So the only other factors were he'd never returned to the country, he'd been isolated from German culture, he doesn't know anything about German culture, and so.
About Mr. Malik's point, which seems to be the core of his point, that the judge, he says, erred because she did not consider the question that Germany has the same core values, the same customs, the same social behaviour, the same respect for human rights, the same respect for the rule of law that England does, which are all, he says, themes that are relevant and ought to be recognised by the judge.
Well, there are two aspects to that. One is, I mean, that's a very general observation. Broadly speaking, democracies, maybe liberal democratic democracies, capitalist democracies, in any event, an advanced society. And I appreciate Mr. Malik's argument, but essentially, I would have run the argument like this, that irrespective of their politics, irrespective of how they run the country and whether they abide by the rule of law, they are, of course, fundamental issues. But more relevant for the purposes of an analysis by the court is what will be the practical reality? So if, for example, an individual who has, let's say, identifies different on the basis of sexuality or has significant mental health problems, returns to a democratic country, a European advanced country like Germany, that person may end up having huge problems there. So you know there may be, you know, racism may be endemic in the part that they want are going to be returned to. There could be a whole raft of problems. So my submission, respectfully, the better argument for the Secretary of State, I've probably done too much arguing on that side today, but the better side would be to say that they are entering a society which has a system of social care, okay, in whatever form that is, whether that is in the form of job seekers allowance or
Well, there's a 55-page booklet that's been put into evidence, which shows what he, as a German citizen, German national, would be entitled to.
yes.
And
Yes,
what
well,
we
there we
get is the judge saying he'd be entitled to benefits on return.
But I would say that's enough. That book wasn't before the first-tier judge,
I think it was.
was it?
Yes. Yes, that.
Okay, then my apology. I stand corrected. So, well, actually, that may be in my submission. That may be enough. He gets state benefits. I mean, really, that says it all. Because if he does, that means he's probably entitled to some housing. That means he's entitled to.
So how do you square that with a finding of very significant obstacles into integration? That's, I mean, this
Because
is what's bothering
integration
me.
is not-
Paragraph 29. I have, of course, taken into account that Germany is a European country and that he'd be entitled to benefits if he wasn't able to find employment. But overall, I'm satisfied he'd face very
Yes,
serious
because I justify and I would defend the first tier on that for the simple reason that integration is not simply about subsisting. It's not simply about him not being starving, hungry, and without roof over his head. Integration is much more multidimensional than that, and it is also focused on an individual being able to develop relationships with other people in society.
And what is
Meaningful
the obstacle to developing relations with other people in society apart from the language obstacle?
A lack of familiarity, an assessment of their characteristics. So yes, I mean, I'm just aware of the time because Mr. Malik wants to come back, but of course, there would be obstacles where there is no familiarity. So very simple answer. If you go back every year to Germany, if his family had gone back every year to Germany, he'll recognise places, may have formed some relationships. Those are relationships and places that are familiar and which he can cling on to in the hope of starting out. But he's going to a blank canvas, really, with nothing to equip him with the challenges that he would face. And so cumulatively, I say that all of the challenges brought together do amount to very, very significant obstacles. And that was something that Specialist Tribunal concluded on, and something that a specialist Upper Tribunal concluded on. Ultimately, from Mr. Ackom's position, the decision is legally correct and is not irrational. It has brought into play all of the relevant factors and has set out reasons why those factors reach very significant obstacles, meet the high test, meet the elevated threshold for that, undoubtedly. And I think this is really a real testament to the judiciary in this country. But it's quite plain that Judge Smith may not have arrived at that conclusion. No one in this room may have arrived in that conclusion, but that is not, and certainly the British public may have disagreed with it, but that really is testament to proper decision making that follows the law. And if the law is insufficient or if it's too broad and too liberal, then that's for Parliament to change it. But ultimately, I say, this judge followed Kamara really in proper substance, properly took that apart and applied it. And so for those reasons, it cannot be said in my respectful submission that the decision is irrational. And my lords, my lady, I'm grateful. Thank you.
Thank you very much, Mr. Sedman. Mr. Malik.
Milady, Lords, I, as you'll recall, made 5 separate points in my opening, and I'll leave it to the court to decide whether those points have been answered by my learned friend. But I do emphasize that those are separate freestanding points. My learned friend concluded his submissions by saying that the decision is not irrational. Of course, you have a point about proper approach, and you have the point about reasoning. May I just respectfully pick two particular points from the submissions that my learned friend has made in reply. You recall that my learned friend started his submissions by saying that the facts in Kamara are sort of comparable with this case, essentially adopting a tentative observation that Milady made at the outset. Now, on reflection, I think it would assist the court to compare the decision of the tribunal in Kamara and then to test my submissions by reference to it. Can I just take you to tab 6 of the bundle, please? Just one paragraph in Kamara which you haven't looked at, and which I think may assist the court to test my arguments. That is paragraph 12, page 134. So Lord Justice Sales identified 4 particular features of the tribunal's decision, and you'll immediately see that what is missing. So the first is Roman 1. There is self-direction that the burden was on Mr. Kamara, and the word very showed an elevated threshold, missing from this decision. The second point is Roman 2, that there are no family friends in Sierra Leone. Keep that to one side, but see the third point. There are other factors. There is self-direction that many migrants who seek new life in other countries thereon will have little experience or knowledge of the language.
Lost you. Where are you now?
Sorry, paragraph 12.
Yes, I see. Yes.
Roman 3, it's middle of that paragraph.
Yes.
And this may address a concern that my lord expressed. Now, we know, of course, that thousands of people come to this country every year, and thousands of people move to Germany every year with no or little knowledge of English or German. And that is the point that is made at Roman 3. And then see, in Sierra Leone, the position was that the English was the officially recognized language.
But not used day to day.
Day to day, precisely. But here, the objective evidence is that it is possible to get by in Germany using just English, just quoting the exact words, since it's widely enough spoken for you to use in most regions without too many problems.
Is that not really the same thing? I mean, it's Germans at home are not going to use it day to day. It isn't actually an official language in Germany, obviously. It obviously is widely understood, but it's not going to be something that people use at home.
No, but the evidence is it is possible to get by in Germany using just English.
Well, is that not consistent with this?
No, because of the non-verbal cues and cultural norms and things like that.
Yes, so it wasn't a normal. It wasn't a language. And then if you read on that sentence, you'll see that Mr. Kamara did not seek any of the local languages. And then the society in Sierra Leone is a highly contextualized society. Many things in the language are not expressed. This is the point that Milady was seeking to make. If you read on that sentence, my Lord will see the point that is being made. And Mr. Kamara had no familiarity with all that. And then see the fourth point. which is that there's continuing hardship experienced by population in that country. There's Ebola, there's no social security, etc. Now, that is a classic example of a lawful decision. And when you test my arguments by reference to that paragraph, you'll see in my submission that the decision made here is unsustainable. The second point to pick is what my learned friend said about the ability to learn English, the ability to learn German. You have my point that, well, English English alone is enough to get by in Germany. But if
He
I'm
says it wouldn't be within a reasonable time.
yes, now this is not what the Upper Tribunal said. Sorry, this is not what the First-tier Tribunal said. The judge did not say that Mr. Bonsu would not be able to learn Germany within reasonable period of time. But the point made in my submission is a bad point on the evidence anyway. Can I just take you to one document in the supplementary bundle just to make the point good? This is the objective evidence that I referred to in my opening submissions. The document how widely spoken is English in Germany. This is page 97.
Yes.
The document starts at page 97. It's accurately summarized in the decision letter. But can I just take you to page 106 and 107? So assume that language is a real problem. So 106, you'll see that the objective evidence provides a basic description of English, German words. And then see what is said at 107. You'll see a reference to an app that is used by over 100 million people. And the point is that it has an excellent overall reviews. It's easy user interface and emphasis on quick learning and progress. I mean, why is it that this Mr. Bonsu cannot learn German swiftly with that evidence? This was referred to in the Secretary of State's decision. It was before the First-tier Tribunal. Mr. Bonsu made a statement that did not deal with it at all. In terms of disposal, I thought my learned friend's position was that if you find an error of law as contended, then you can make the decision. Do not propose to say much on that. I thought that it was best for Mr. Bonsu for this case to go back, because all you have from Mr. Bonsu is the witness statement that I've shown you. No reasonable judge, in my respectful submission, can find that exception 1 apply on the basis of that witness statement and the other objective evidence that you have. I'm very grateful. So these are the points that I wanted to pick in my reply. You have my other submissions.
Thank you very much. Well, thank you both very much, and thank all three of you very much. We'll reserve judgment in the normal way. You will be supplied with the judgment in draft for you to correct our English and typing, but obviously not so as to re-argue the case. I would mention at this stage that we have had from Mr. Stedman's side a list of those to whom the judgment should be sent. I'm not aware of having anything comparable from the Secretary of State. And that being so, it would not go to anybody other than you, Mr. Malik, absent a list. But I doubt that will be
Whoever it is in
provided
GLD.
if it hasn't been provided already.
Yes.
Sorry, Mr. Malik.
I'm sorry. It's just that I did check the position with my secretary solicitor. An email my solicitor says was sent with the form to the court, but I'll
Could you
double.
possibly get him to email one to my clerk as well, just to be on the safe side?
Yes, I'll
please?
do that right away. Yes.
Again, in accordance with normal practice, we'd be grateful if once you do have the draft judgment, you'd seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. And then finally, I ought just to remind you of the importance attached to the embargo. We obviously will have a list of those on each side to whom the judgment should go. Should you think of anybody else who should see it, you need to come back to us. This court attaches very considerable importance to the embargo being complied with. We'll leave it there. Thank you very much.
Court rise if able. Please remind the courtroom that the live stream is still running.
Yes.
Yeah. Just cut and paste your email address to come to me and say
Hiya. I was hovering outside, giving my judge a hey.
cut and paste emails in.
Justice Andrews wants to see the new one the
Oh, I see.
is it right?
Yeah, they should have it because I asked for the list to be sent.
Legally, by email.
Yeah, of course they can have my email. No problem.